Hi, and welcome to this installment of Bergeron Briefs. My name is Art Bergeron. I'm an elder law attorney. As many of you know, I work at Myrick O'Connell. We're a full-service law firm. There are 60 of us. I do nothing but elder law. Usually, on these shows, I am talking to somebody, but today I'm not. So you have to excuse me if I'm a little more nervous than usual because I'm not just asking questions, I'm having to talk. But I wanted to devote this show to actually a very important thing that has happened that you need to be aware of as an advocacy matter. You need to be aware of it as a planning matter. This year in Governor Baker's budget, Governor Baker has proposed certain sections of that budget which can significantly affect planning that you might want to do, but even planning that you think you've already done regarding dealing with a set of mass health related issues. As many of you know, and as I've mentioned here on the show before, most of my clients and most elder law clients in general are people who are either worried about Alzheimer's, or they have Alzheimer's, or they know somebody, they have a loved one who does, or who has dementia caused by some other disease. The reason why Alzheimer's and dementia are typically considered to be almost synonymous is that about 70% of all those people who have dementia symptoms have them because of Alzheimer's. So anyway, most elder law attorneys are talking about these issues a lot. And those are the issues that are being changed. But before I talk about the changes, I need to give you some background in terms of how we got here. The reason why seniors have to do so much planning around these issues, around dealing with what happens if you're sick and the symptoms are dementia, is that cluster of diseases and symptoms is the one thing that is not covered by Medicare, which is really important. As you know, Medicare is health insurance for old people. To get a sense of the effect that Medicare has had on our society, you should understand that Medicare was passed in 1965. In the 1960 census, it was found that over 30% of all people in America over age 65 were poor. That is just hard to believe now. It's just hard to believe. Today, or as of a few years ago, recent census data suggested that about 7% of people over 65 are poor. So what happened? I mean, there were a lot more old people now. What happened? Well, in the old days, when you got old, you couldn't get health insurance, just like you can't get it now, and that's why there's Medicare. And so people got old and got sick and went broke. And a lot of them did, and that's the reason for those poverty numbers. And clearly that has changed now as a result of the presence of Medicare. So if you get sick now and you have cancer and you need operations and you need chemotherapy and you need all this stuff, Medicare pays for that. Or if you have diabetes and you need, once again, testing and operations and equipment, Medicare pays for that. If you have Alzheimer's though, and so your major symptom is dementia, and you're not into the really advanced stages of Alzheimer's, so the dementia is not causing serious physical problems, but simply causing you to need someone to help you get dressed, or someone to help you take a shower, or someone to be there all the time so you don't wander off. Well, Medicare doesn't cover any of that. Medicare only covers skilled care. You know, really, when you think of Medicare, you think of medical stuff, skilled care, nursing care, hospitals. It doesn't cover the cost of simply needing somebody at home to be with you, or needing to be in a place, a skilled nursing facility, where there are people who can be with you all the time. So it's for that reason that folks who are older, that one of their biggest fears is that they know their financial situation is such that they will be okay financially, even if one of them gets sick, as long as nobody gets Alzheimer's. So many people are doing planning to deal with that. Now, the reason why they're doing that kind of planning is because nursing home care, as well as substantial amounts of home care, care in the home, not necessarily by a skilled caregiver like a nurse, but just by a home care worker, is covered by the Medicaid program as opposed to Medicare. But Medicaid, and in Massachusetts, by the way, Medicaid as opposed to Medicare, which has national regulations that are nationally administered, so the rules are the same every place. Medicaid is a partnership program between the federal government and each state. So Medicaid has 50 different versions depending on what state you live in. So in Massachusetts, the name for Medicaid is Mass Health, and the rules in Massachusetts are different from those in some other states because the federal government draws some broad parameters regarding how the regulations in these programs run in each state. But each state typically has quite a bit of flexibility in terms of modifying those rules in their own state. So many people that I talk to are trying to deal with the fact that they want to make sure that if one of them, or if they're single, if that person themselves needs to qualify for Mass Health, that they'll be able to do so and won't get wiped out. And ideally, they want to structure things. My typical clients, my clients Frank and Mary, my make-believe couple whose goal in life is to die and be buried in the backyard and leave whatever they own for their kids. The typical person who has saved up and now lives in his house and has saved some cash would like to be able to leave something to their children after they die. Now, they may not be able to leave them any cash, but they might at least want to leave them their house. And it's been my experience that's the most common situation, that people, when they die, want to think that their kids are going to get the house, maybe because one of them needs to live there, or maybe because they're just going to sell the house and divide up the proceeds, but at least that way the parent feels that they left their kids something. Now, this gets to the kind of planning that is now being done and that has been done and the way that this new law may affect it. Now, the law, or that is being proposed, is all in something called outside Section 11. Now, what is that? When a governor proposes a budget, the budget typically has a whole bunch of sections in it that are requests for money, the budget. But the governor will typically, and this happens pretty much every year, also propose so-called outside sections to the budget. These are sections of the budget, sections that are actually changes in the law, but they are changes in the law that, in the governor's presentation, she says, is either going to raise extra money or cause the current programs that are running to cost less, and in that way to affect the budget. And so these outside sections are presented and dealt with by the legislature as a package together with the budget itself, right? So while most pieces of legislation that get sent into the legislature or proposed by a legislator go through a long committee process, often, there are hearings and things will go to committee, and often if there's some controversy about it, there'll be a study committee to see if there can be a compromise developed over several years. That's kind of the typical legislative process. Well, not so with the budget, right? Because as you can imagine, the budget in its nature has to get passed. The budget is always proposed in January and is supposed to get passed by July 1 because the Commonwealth is on a fiscal year and the fiscal year begins July 1. And so theoretically, if the budget isn't passed by July 1, there's no money. And so there is an incentive for legislators to get the budget passed by July 1 or thereabouts. So this matter, this outside Section 11, together with the other outside sections of the budget, will get dealt with this year and will get dealt with very soon. It is, as I speak to you, it is February. This matter will be dealt with over the next several months. So you need to understand what these provisions are that are in a couple of the provisions in this outside section. So the outside section is very long. There are some provisions in it that I will not go through today because they don't affect most people, but there are a couple that really do. Now let me give you the examples of the people who might be affected and then the way the outside section affects them. So if you came to me today as a single person because you were divorced or because your spouse had died, and you told me that you wanted to try to protect some of your assets, in the event that you later on needed to qualify for Mass Health, I would tell you first of all, well, if you want to qualify for Mass Health, you have to have less than $2,000 in countable assets. Your home, however, is not a countable asset, so you can own your home and still qualify for Mass Health. The catch is, oh, and by the way, you can own your home and qualify for Mass Health as long as when you are trying to qualify, you say on your long-term care application that it is your intention to return home. Even you don't have to show that you really could actually return home, only that you intend to return home. So that's the way the law currently works. And then once you have qualified for Mass Health then will put a lien on your home to assure that following your death, to the extent that Mass Health has paid any money on your behalf, Mass Health gets reimbursed. So that's how the law currently works and how it has worked, well, really for as long as I've been practicing law, which seems like forever, but is only about 30 years, right? So that's how the law currently works. So the typical planning device to deal with that, if you're a single person, would be to transfer to your children or to an irrevocable trust for the benefit of your children a so-called remainder interest in your home. Well, what is that? So when you own your home, you own it typically in fee. That's the legal term, in fee, F-E-E. And the legal significance of that, among other things, is that you own that home, unless you sell it, until the end of time, as long as you live that long. Now, of course, most people don't. So what that having a property in fee also means is that if you die and you still own your home, that your interest in the property goes through your estate. And if you have a will, well, then the property passes according to the will. And if you don't have a will, the property passes according to these special rules called the rules of intestacy. But you don't have to own your property in fee. You can actually divide up that space of time between now and the end of time, and you can sell or give away chunks of that to people. And the most common division is a division between all of the time until you die and all of the time after that. And the time between, if you own your home, the time between now and the time you die, if you had an interest in your property that was just for that time, would be called a life estate. That's a life estate. The remainder of the time between the moment that you die and the end of time is called the remainder. And so what you would do if you were planning for me and talking about protecting this house is you would transfer this remainder interest in your home to somebody else, probably to your children, or if you're concerned that your children after your death may argue about what to do with the home, you may want to transfer it to a trust, naming one of your children as the trustee, for the benefit of all of the children. So there are a number of ways in which you can transfer the property. The main thing is you're transferring the remainder to someone other than you. And you are keeping in the property a so-called life estate. Now, why would you want to keep the life estate as opposed to simply transferring the entire property to your kids? Well, really for a couple of reasons. One, and I think the most important for most people, they want to make sure that they stay in control of their house as long as they're alive. They want to make sure, because they've all heard the horror stories, that their kids don't throw them out, or that there aren't arguments about the house, excuse me, or that one of their children doesn't move in, whom they don't necessarily want to have move in. And so they want to keep control. And so typically people will want to keep a life estate. If they keep a life estate, that means that they continue to be responsible for paying the taxes and the insurance, excuse me, and the other bills regarding the house. But they have that same sense of control. As a matter of fact, the tax bill continues to actually get sent to them as the owner of the life estate. Now, the effect of all of that, if that person then needs to qualify for Mass Health, is, once again, Mass Health, as long as that person could demonstrate that they had other assets worth less than $2,000, they would qualify for Mass Health. Mass Health would put a lien on their life estate, and if they sold the property during their lifetime, then that lien would get enforced by Mass Health, and Mass Health would be owed money on account of that piece of the value of the property attributable to the life estate. But if they held the property until they died, upon their death, the life estate would expire. And therefore, the lien would expire also, so that their children, when they went to sell the property, would be selling the property lien-free. Now, the other reason why people will want to transfer a property but keep a life estate in it is that for estate tax purposes and for capital gains tax purposes, if that's the case, if the older person kept a life estate, when they die, that property is includable in their estate for estate tax purposes, which is usually meaningless, since if their estates are worth less than $1 million, there is no estate tax. But further, because it's includable in their estate for estate tax purposes, the so-called tax basis in the property jumps from probably the amount that it was when they bought the property to the date of death value. And therefore, when their children go to sell the property, when they sell the property, instead of having to pay a capital gains tax regarding the sale proceeds, they probably won't have to pay one, because the capital gains tax is computed on the capital gain. And the capital gain is the difference between the sale price and the tax basis of the property. The tax basis is usually what you bought it for, but if you hold property until you die, the basis jumps to your date of death value, so that if your children then sell the property, then they'll sell it capital gains free. Now, so currently, if you have transferred the property and kept a life estate and then end up qualifying for Mass Health will put a lien on the life estate, but upon your death, that lien will expire. One of the pieces of outside Section 11, however, changes that and says that whatever the value of if you were qualified for Mass Health, whatever the value of your life estate at the moment of your death, Mass Health will continue to have a lien on the property for that amount of value, no matter when the property gets sold. It can be sold next month or it can be sold next year. So Mass Health will now recover a significant amount of money after the death of the person who has done this planning. Similarly, if you own a property jointly with someone, with one of your children or with one of your brothers or sisters, if you have a joint interest in that property and you qualify for Mass Health, and Mass Health puts a lien on that property, following your death, that lien will continue to apply to whatever the value was of your joint interest in that property. And Mass Health will recover that amount at the time that that property gets sold. So that is a major change. And most importantly, as the outside section is currently drafted, it will affect everyone who applies for Mass Health as of a particular date. As it's in its current form, it's like the middle of July of this year. So even if you've already done all of this planning and you already have transferred your property out and kept a life estate, if you then need to qualify for Mass Health after this magic date, there will be a lien on your life estate at the time of your death. So that's big change number one. Big change number two, to understand this one, you need to understand the typical estate planning or Mass Health related planning that people do if they're married. I'll tell people in that case, if you're married and you own your home, that's okay. If one of you needs Mass Health, then you can, because that person is in a nursing home, you can simply transfer your home at that point immediately to your spouse. Because to qualify for Mass Health, you need to show that you have assets of less than $2,000. Your spouse, on the other hand, can have assets of his own or her own, including a home, the home itself, as long as it has an equity of less than $828,000. So one spouse, if they need nursing home care, can simply shift their home to their spouse at any time. Inevitably, when I tell people this, they say, that can't be right. What about that look back? Well, there is no look back period regarding transfers between spouses. So this transfer can literally be done the day before the person in the nursing home applies for Mass Health. Similarly, other assets can be transferred to the spouse at home. While there are some caps on the amount that the spouse at home can have, and I'm not going to go into those here, the main thing is that the spouse at home can have substantial assets. And when the spouse in the nursing home dies, as long as that spouse dies before the spouse at home, any lien or any possibility of recovery that Mass Health might have had against the estate or the assets of the spouse who died in the nursing home expires. There is no ongoing lien or claim that Mass Health would have against the estate of the surviving spouse. Well, that too is about to change. Under a different provision of outside Section 11, the surviving spouse in that case, and this is in the case of anyone who qualifies for Mass Health, who applies for and qualifies for Mass Health after this magic day, which is right now in July of 2016. If that person qualifies for Mass Health and receives Mass Health benefits and then dies, and their spouse later dies, no matter when, whether it's 6 months from now or 10 years from now, and no matter how much is in that surviving spouse's probate estate, Mass Health will have a claim against that probate estate. That is a huge, huge change from the way that recovery, that Mass Health estate recovery has occurred over the last, as I mentioned, 30 or actually it's almost 40 years now, over the amount since 1977 when I started practice. These rules have not changed. I take that back. There was a change, a proposed change that passed 10 or 15 years ago, around 2003, when a similar kind of attempt was made to recover against life estates and other interests in property that weren't going through probate. That was passed by the legislature because no one was paying attention. It was one of these things. It got passed as part of an outside section to the budget. And then there was such an uproar that the legislature reversed themselves a year and a half later. Many of us who do this kind of work have a great concern that a similar thing is about to happen, that people are going to be unaware of these proposed changes and are not going to talk to their legislators about it, and that therefore these changes are going to happen. So to summarize, even if you have already done what I often refer to as asset protection planning, if you're an older person, that is designed to structure things so that if you need to qualify for Mass Health, you'll be able to do so. And then if you die, the assets that your spouse has will be safe from any Mass Health claim. Even if you've already done that planning, if this particular outside section to Governor Baker's budget passes, you're going to need to be redoing some of that planning if you still want to have any of those assets be safe. So these are important things. You need to talk to your legislator, talk to your lawyer, get acquainted with what's going on, and follow this. The reason why I think it's especially important that you follow this is that if, like back in 2003, the legislature makes a deal with the governor and changes the rules so as to specify that any transfers of life estates or of other interests that occurred before a particular date, or any other estate planning that occurred before a particular date, is grandfathered, then it's going to be in your interest to get those things grandfathered like very, very soon, before this budget ends up getting passed and this change ends up occurring. So I'm sorry that I didn't have a guest today. As I mentioned, I hope I didn't sound too shy from just being the only person here. I hope that you found this informative. This is time sensitive, so you need to be paying attention to this. Talk to your lawyer about it and see if there's anything that you need to be doing over the next several months. And if you're concerned about this, you may also want to talk to your legislator. Thank you very much, and I look forward to seeing you on the next installment of Bergeron Briefs.